with 2 wins and a total score of 424 out of 600. We have Team F, that is
The Supreme Court of Pakistan is now in session, hearing the case of Universalized Access Foundation versus Federation of Pakistan. Honorable judges are Barrister Salman Safdar, President of the bench as well, Sheila Qureshi, Isam bin Haris, Hafsa Ahmed, and Barrister Asad Rahim. Applicants have 30 minutes, respondents have 30 minutes. Now the applicants may begin.
Councils, before we resume the hearing, could the court staff please remove the bouquet from here for clear view of the audience? And secondly, if you could make sure that your mobile phones are switched off and there is no disturbance during the course of court hearing. Thank you.
Greetings, Honorable Justices and Chief Justice of Uzbekistan. May it please the court, I am Constable 1 for the team representing applicant in this case before the Honorable Court today. And for the course of next 16 minutes, I will be addressing issue number 1 and 2, whereas my co-counsel will be addressing issue number 3 and 4 for the course of next 12 minutes. And 2 minutes are reserved for rebuttals. May I have court's permission to proceed with the pleadings or the summary of the facts?
Proceed as you please.
Much obliged, Your Excellencies. There is an issue, first of all, that whether UF has local standard before the Supreme Court of Uzbekistan in the present case. And my submissions in respect of issue number 1 is that, first of all, the petition mandable for public interest litigation does not question local standard. And second of all, the requirements of public interest litigation under Article 184, Clause 3 is satisfied. May I proceed with my first submission? Much obliged, Your Excellencies. My first submission is that the instant petition is a public interest litigation, which is the legal action initiated in a court of law for the enforcement of public interest. And here in this instant case is filed by UF on behalf of Shadia, Zulfi, Askari, Shamaila and Shaheen, whose fundamental rights under Article 9, 14, 25 and 25A of Constitution of Uzbekistan are violated, and since these students represents vast majority of school-going children and state of their education during pandemic as per the fact of 17 of the Moot problem. And therefore the instant petition qualifies the definition of public interest litigation. And the question of local standard is dispensed with in public interest litigation as it was held by this court in the case of Ardeshir Kowazri and others versus Karachi Building Control Authority. It held that in view of public interest, the more serious issue is that the less significance is attached to arguments based on appellant's lack of standing. And further reliance is placed on the case of Benazir Bhutto versus Federation of Pakistan, where this court dealing with the issue of local standard maintained that where there are violations of fundamental rights of a class or a group of persons who are unable to seek redress from the court, then the traditional rule of local standard can be dispensed with and the procedure available in public interest litigation can be made use of it if it is brought to the notice of the court by a person acting bona fide. And to assist the Honorable Court that how a person is bona fide, this issue was addressed by this court in the case of Dr. Muhammad Tahirul Qadri versus Federation of Pakistan, cited in footnote number 8 of the submitted memorial. It is told that it is something which is not to be proven, but bona fides are to be presumed unless and until mala fides are attributable.
Counsel, in the case of Dr. Muhammad Tahirul Qadri, I understand that the Supreme Court found that that individual did not have locus standi, correct?
Yes, yes.
So that means locus standi must still be proved to some extent, even if, as you mentioned in the case of Benazir Bhutto, they said less significance, but still some significance exists.
Yes, yes.
How do you prove your locus standi exists, even if it is a matter of just giving less importance? Who are you to bring this petition on behalf of the aggrieved person?
Yes, since the locus standi established under Article 184.3, which has the requirements which I will be satisfying, and it is satisfied in the explained case as well. The requirements are that the issue should be of public importance and the enforcement of fundamental rights.
Counsel, could you please give your name once again?
Hansa.
Hansa. Hansa, I have two questions for you. The first one, the case law on which you are relying, Benazir Bhutto versus Federation of Pakistan, it does not say how many judges presided over this matter and gave this judgment. Do you have details?
Yes, there were 11 bench judges.
How many judges were there in this case? Are you aware?
I may know, but I do know that there were 11 bench.
The reason I am saying, please be mindful that this is a 5-member bench, and we would appreciate if you give citations which contains the same number of judges. This was my concern. My second question to you would be, why have you bypassed the constitutional remedy under 199 before the High Courts and you have directly approached the Supreme Court? Could you please direct your submission on this?
Your Excellencies, as the issue concerns the whole majority, the vast majority of Uzbekistan, that's the reason why we have been before this Supreme Court of the Uzbekistan, and it was also mentioned in fact number 17 of the Moot problem that the students mentioned that those are 5 students, but this shows the vast majority of Uzbekistan. May I proceed? Much obliged, Your Excellencies. My second submission is fact official number 1 is that the requirements of Article 184(3) of the Constitution of Uzbekistan have been satisfied. And even if this court holds that the petitioner does not hold the local standard or the definition of public interest litigation, it is submitted in the alternate that the requirements of the 184(3) are satisfied. That is, first of all, the matter should be of public importance, and the connotations of public importance were elaborated by this court in the case of Manzoor Ilahi versus Federation of Pakistan, cited in footnote number 11 of the submitted memorial, that public importance refers to something which is to be shared or participated in or enjoyed by the public, and it is not limited or restricted to any particular class in the community. And in the case of Benazir Bhutto versus Federation of Pakistan, again, having regard to the connotations of the words public importance, it will be for the Supreme Court to consider each case whether the element of public importance is involved in the enforcement of fundamental rights, irrespective of the individual's violations or the infractions of a group or class of the person. And then instant case has been filed by UF on behalf of the children whose fundamental rights under Article 9, 14, 25 and 25A of the Constitution of Uzbekistan have been violated, which shows the vast majority of all of the Uzbekistan in the instant case. And furthermore, UNICEF reported that education system in Uzbekistan was adversely affected during pandemic, as it is cited in footnote number 14 of the submitted memorial as well. And the closure of schools during pandemic has severely affected the education of children across the country, which represents a large number of Uzbekistan's population. Thus, therefore, it involves the question of public importance.
Counsel, if I could stop you there for a minute. I want to relax it. So it goes back to the same question as to why the 5 students who are agreed are not directly before us, and why the UAF is before us instead. Could you offer some assistance on that?
Yes, it was all in a case PAD 2009 SC 217 that jurisdiction of Supreme Court under Article 184(3) can be invoked even by an individual if the matter involves the questions of public importance of any fundamental right, enforcement of any fundamental right. May I proceed?
Counsel, the question is why those 5 individuals themselves are not before us, and why a foundation such as yourself is. If you could assist us on that, because the anxiety of any court, if it is to engage in a PIL of this sort, is to ensure that there is some sort of bona fide of this sort. But then we have to be satisfied that the absence of the aggrieved parties is not a problem because of your presence. How do you reconcile those positions?
Yes, since as all the children are minors in the instant case, that's the reason why UF has, on behalf of them, has filed a petition before this honorable court. May I proceed? The second requirement of Article 184(3) is also satisfied, that is the fundamental rights. And the Constitution of the Uzbekistan does not define the term fundamental right, but fundamental right are those rights which have been recognized in the supreme law of the land, that is the Constitution of Uzbekistan. And in Chapter 1 of Part 2 of Constitution of Uzbekistan lays down the fundamental right. And Article 4 of Constitution of Uzbekistan, every citizen enjoys protection of law and to be treated in accordance with law. And the importance of fundamental rights can be determined from the fact that, pursuant to Article 8 of the Constitution of Uzbekistan, laws inconsistent with or in derogation of fundamental rights are to be void, and the facts of instant case evidence that fundamental rights under Article 9, 14, 25 and 25A of the children have been violated, who represent the vast majority of the school-going children, as it is mentioned in fact number 17 of the mooting problem.
Council, are you familiar with Article 38 of the Constitution?
Which?
Article 38.
38.
Are you familiar with Article 38 of the Constitution?
Yes, sir.
On the promotion of social and economic well-being. That article specifically mentions the right to education. Is there a reason why you're mentioning Articles 9, 14, and 25, which aren't directly associated with education, but you haven't mentioned Article 38 of the Constitution?
Since it's the responsibility of federal government to promote those rights, and it includes the right to education as well.
Yes,
as
absolutely. So why haven't you mentioned Article 38?
As it is, it has specifically violated these rights of those minors in same case.
Okay, and are you aware of Article 38B of the Constitution, within which you've just mentioned correctly, it's promotion of well-being. But Article 38B says within the available resources of the country, right? And so if this isn't a right you're asking for, there's a proviso in the Constitution that says to the extent that there are resources in the country under the Constitution. So their argument, I understand the respondent's argument, is that this is not within the available resources. So how do you argue that this is a fundamental right for which there are available resources?
Since firstly and foremostly, the article you have mentioned is not a fundamental right. That's why it cannot be invoked before this honorable court. Much obliged, Your Excellencies. May I proceed to my second issue?
Yes.
Much obliged, Your Excellencies. The second issue is that whether a right to internet access is a fundamental right under the Constitution of Uzbekistan. And my submissions in respect of issue number 2 is that, first of all, right to internet access is a fundamental right under the Constitution of Uzbekistan. And second of all, international guarantees can be read into the Constitution of Uzbekistan in the absence of domestic legislation. So moving towards my first submission, that is fundamental rights includes those which have been judicially interpreted by this honorable court. And in the case of Shaila Zia versus Wabda and others, this court extended the scope of Article 9 of Constitution beyond its explicit language and held that the right to life guaranteed by Article 9 of Constitution of Uzbekistan included the right to a healthy environment. And this court justified this interpretation by
If I could pause you there, you mentioned and you've relied quite principally on Shaila Zia versus Wabda and others, and you've stated, and you just said at the rostrum as well, this court extended the scope of Article 9 of the Constitution beyond its explicit language and held that the right to life guaranteed by Article 9 included the right to a healthy environment. Is it not the respondent's case that they are doing everything within their limited means to ensure a healthy environment, and would granting you this relief not actually compromise such a situation?
Since as the instant case is filed before this honorable court, because of the children are showing the vast majority of whole of the Uzbekistan, that's the reason we are here before the federation.
Yes, but how does affirming your relief lead to a healthy environment as in the light of the Shaila Zia judgment?
It was also called that education is the bare necessities under Article 9 also includes education, proper health, and my children can, have you submitted? The bench has been submitted by...
No, but my question remains, if your relief is granted, will this not affect public health in a way that is detrimental to these students that you are representing via your organization?
Your Excellencies, we are arguing that the internet access should be available throughout the Uzbekistan, and it is not that the honorable court should direct to open the schools or education institutes. We are arguing that there should be internet access available throughout the country.
The reopening of schools with SOPs, this is in your memorial, no?
Yeah. This is the remedy.
Yes. So is this not a remedy you want?
This remedy we want, but that with SOPs, this is mentioned there.
No, thank you.
Much of your expenses. And internet access similarly is recognized as integral part of fundamental right. And in the case of Sayyid Muhammad versus Federation of Pakistan and others, the Islamabad High Court held that access to internet is a fundamental right under the Constitution, and it is the duty of the state to ensure that the residents of all of the country should not be deprived of it. And the Islamabad High Court, while emphasizing the importance of right to internet access, explicitly stated technological progress has definitely made access to internet facilities as integral part of the constitutionally guaranteed rights under Article 9, 19 and 19A of the Constitution. And further reliance is said to the Kerala High Court in Fahima Shiri RK versus State of Kerala, cited in footnote number 20 of the submitted memorial. It was told that right to have access to internet becomes the part of right to education as well as right to privacy under Article 21 of Constitution of India. And furthermore, in Anuragha Vasan versus Union of India and others, cited in footnote number 21 of the submitted memorial, and PUCEL versus Union of India, so the Supreme Court of India recognized the importance of right to internet access on the touchstone of fundamental right.
Counsel, this judgment of the Islamabad High Court that you have just referred to, this is the Supreme Court. What value do we attach?
It is a persuasive source, it just to assist the honorable court.
All right. Thank you.
Much obliged. Internet is therefore a fundamental right. The jurisprudence set by this honorable court and the courts of India manifest that right to internet access is an integral part of constitutionally guaranteed fundamental rights, and the right to internet access is therefore a fundamental right. Your Excellencies, my second submission in respect of issue number 2 is that international guarantees are to be read into Constitution of Uzbekistan. May I?
Formulate your points very quickly. Conclude, please.
Much obliged, Your Excellencies. The international guarantees can be read into fundamental rights guaranteed under the Constitution of Uzbekistan, as internet to access is a grey area of law and there is no domestic legislation particularly. And it was held in a case by this Supreme Court, Ms. Najib Zara Limited versus the Government of Pakistan, cited in footnote number 23 of the submitted memorial. It was held that we are of the view that nations must merge with the international community and the municipal law must respect rules of international law even as nations respect international opinion. The Committee of Nations requires that rules of international law may be accommodated in the municipal law even without express legislative sanction, provided they do not run into conflict with acts of parliament. And similar stance was taken by Kerala High Court in the case of Fahima Shiri RK versus State of Kerala, cited in footnote number 24 of the submitted memorial. It was held that the international conventions and norms are to be read into fundamental rights guaranteed in the Constitution of India and in the absence of enacted legislation occupying the fields where there is no inconsistency between them. And in international law and the Committee of ESCR, which is the monetary body of ECSR to which Uzbekistan is a signatory, has categorically stated that the education must be physically or economically or online, have to be accessible via some modern technology, which, considering the present circumstances, is the need of an hour. And the UN Special Rapporteur on Freedom of Expression submitted his report to the UNGA and declared that access to internet is a fundamental right as a human right, cited in footnote number 626 of the submitted memorial. And the Charter of Human Rights and Principles for the Internet also recognize the right to use the Internet for education. Thus, the right to internet access is recognized under international law in the present circumstances, and even if this court holds that right to internet access is not a fundamental right, it is submitted in the alternate that international guarantees can be read into fundamental rights in the Constitution of Uzbekistan in the absence of domestic law, as I have mentioned the case of Najib Zara. The next two, if the Honorable Court has no query, my co-counsel will be addressing.
Thank you very much for your assistance.
Much obliged.
Counsel, may we have your name, please?
Greetings, Your Excellencies. My name is Ahsan Ali.
Sorry?
Ahsan Ali.
Yes, sir.
May I proceed with the kind permission of Mr. Honorable Court?
Please.
Much obliged, Your Excellencies. The third issue concerns whether the lack of internet access constitutes a violation of fundamental rights under the Constitution of Uzbekistan. I'll assist this Honorable Court by establishing violation of each fundamental right established under the Constitution of Uzbekistan. First of all, lack of internet access violated right to education of children of Uzbekistan. Right to education has been recognized under Article 25A of Constitution of Uzbekistan. However, Shadia, Zulfi, Askari, Shumailia and Shaheen in specific, and the students which they represent, they are the vast majority of school-going children of Uzbekistan and staying on the same position. Their right to education have been violated. Particularly, Shadia's school was closed, she couldn't attend her classes. Zulfi waited for 2 months, however, due to closure of his school, he had to return back to his village, his right to education was violated. Thirdly, Askari spent his time playing with his friends and he was promoted from grade 7 to 8 and therefore his right to education was also violated. Fourthly, Shumailia, although she studied in a private school, her school provided daily basis lessons from WhatsApp and she also had a TV at her home. However, due to her siblings, she couldn't attend her proper classes and therefore there was her right to education was violated because she was promoted to grade 8 from grade 7 and she had no idea what she studied in her previous class. And lastly, Shaheen, she was a disabled person, although she studied in late school. However, she experienced a lot of problems while accessing the virtual platform that was dedicated by her school. Secondly, lack of internet access also violated right to defend.
Counsel, if I can just ask, the examples that you just quoted, in one of these examples you mentioned yourself that this individual, I think it was Shumaila, who had access to both internet and a television in her home, but she couldn't complete her education because of her siblings. What, if your relief is granted, how does her situation change? She has internet access, she has access to the television. What do you propose that the Federation of Pakistan could do in this situation?
Thank you for the question, Your Excellency. Internet access includes to provide equipments digital equipments by which the students can access internet. Because throughout Uzbekistan there are various families, there are various students who do not have access to mobile phones, which is the main source to use internet. They do not have access to TV, which is the main source for every initiative taken by the federal government. And
so,
without
Counsel, am I supposed to interpret your prayer as a prayer rather than right to access to internet? It should be access to a mobile phone for every individual.
it includes the providence of digital equipments as well. Thank you, Your Excellencies. Moving towards my second point, that is lack of internet access.
Counsel, one short question on the same point. Shadia, Zulfi, Askari, Shumailia, and Shaheen, these are separate individuals with their own facts, possibly different causes of action, as you slightly alluded to right now. How are you extrapolating this into a question of public importance?
Your Excellencies, public importance means an issue which involves public at large. These 5 students, although they are just limited 5 students, but they represent vast majority of school-going children of Uzbekistan. If you go through the mood problem, fact number, I would like to bring into the attention of this Honorable Court to note the fact number 5, which says that Uzbekistan passed provincial laws to govern their respective legal responses. It means that the situation was not only limited to Zalor or Sansetabad, but it was throughout Uzbekistan, and therefore these 5 classified group of children, they represent a vast majority of school-going children, and therefore there is an element of public importance. May I proceed further? Thank you, Your Excellencies. Lack of internet access also violated right to equality, which has been incorporated under Article 25 of Constitution of Uzbekistan. I rely on the case of Northwest Frontier Province Public Service Commission cited in footnote number 36 of submitted memorial, which says that all persons are subject to law should be treated alike under all circumstances and conditions, both in privileges and in the liabilities imposed. If my researcher can please cite the case law mentioned in footnote number 36 and WFP. The court also held in the same case that the guarantee of equal protection provides in that no person or class of persons shall be denied the same protection of law which is enjoyed by other persons or other class of persons under same circumstances. However, in the instant case, Shadia, Zulfi and Askari, they had access to internet, but on the other hand, Shumailia and Shaheen, they had no internet access. This violated their right to equality under the Constitution of Smogistan. Additionally, Article 25, Clause 2 of Constitution of Smogistan also provides for equality on the basis of sex. There shall be no discrimination on the basis of sex. However, in the instant case, Shumailia also she had access to WhatsApp as well as TV, but due to since her brother used to use mobile all time and therefore she couldn't attend her classes through WhatsApp and therefore there was discrimination in the instant case as well. Moving towards my second submission, moving towards my second violation, that is lack of internet access violating human dignity as well, which has been guaranteed under Article 14 of Constitution of Smogistan. Your Excellencies, the case cited by my co-counsel, which was Shailazia versus Babda, it says that in that case, the Honorable Supreme Court of Pakistan read Article 9 together with Article 14 and held that there must be certain bare necessities to protect the right of life, and those bare necessities include education as well. And without education, a person cannot have a dignified and a comfortable life, and therefore, due to lack of education, their right to human dignity under Article 14 of Constitution of Pakistan was also violated. Going towards my second next violation, that is lack of internet access violated right to life, which is protected under Article 9 of Constitution of Smogistan. Reliance is based on the case of Headmaster versus Chairman cited in footnote number 45 of submitted memorial, wherein the Lahore High Court held that the word life include the rights which were necessary for leading a proper and comfortable life, and that the acquiring of knowledge was also a part of, and the state was under obligation to provide all possible facilities and opportunities to citizens for receiving education. Similarly, in the case of Ahmed Abdullah versus Government of Punjab cited in footnote number 47 of submitted memorial, it was held by the Lahore High Court that right to life includes right to education as well. Furthermore, in the case of Sikandar Hayat versus Government of Pakistan cited in footnote number 47, the Peshawar High Court set aside an order wherein the name of a student was placed on ECL, and it was held by the Peshawar High Court inter alia that let the petitioner go abroad for study purposes. Similarly, similar view was held in the case of Khizar Azam Khan versus Northwest Frontier Province University of Engineering and Technology cited in footnote number 48 of submitted memorial. The upshot of these discussions is that the right to life includes the right to education as well, and therefore,
My understanding is that the respondents don't refute the right to education. Is that correct? All of the cases you just cited are with regards to the right to education. I believe that the respondents admit that the right to education exists. You have to draw the nexus between the right to education and the right to internet. What is the nexus between the right to
Your
education?
Excellency, as we all know, modern problems need modern solutions. And since the habit problem was new, and therefore in order to address this situation, these all violations could be precluded from just providing internet access throughout Smogistan.
Except that you yourself have admitted that in two of these situations, the individuals did have access to internet.
As I argued earlier, internet access means providence of digital equipment as well, because it is nowhere mentioned in the facts that Zalor was deprived of, if I have the extension of time to.
Yes, please. Please address the query of the Honorable Member.
Yes, Excellencies, thank you. In the instant case, this nowhere mentioned that there was lack of internet access, but what we say that internet access includes the providence of digital equipment, because Shadia and Shaheen, Shumailia and Shaheen, they had access to internet, but they couldn't get education despite of that. It is because they didn't have those equipments which they needed. Therefore, right to internet access includes the providence of instruments as well, through which they get access to education during the pandemic situation as well. If you have the court's permission and further extension.
Very briefly, would you have any judicial authority that pertains to the right to internet access as a fundamental right, whether from our jurisprudence or from any common law jurisdiction?
I must apply, Your Excellency. This is a great area of law. As my co-counsel already argued, the case of Syed Muhammad it was decided by Islamabad High Court and the Kerala High Court judgment, which says that internet access is a fundamental right. If I have the court's permission and extension of few seconds, I would like to conclude my fourth issue.
We have heard your contentions and we understand the issue. If you could formulate your points and conclude, please.
Thank you, Your Excellency. The remedies we claim before the Honorable Court today include implementation of recovery program so that the loss education can be regained to the students. Furthermore, allocation of education budget to address the current situation and the upcoming situation. Providence of internet access to all, which include the digital equipments as well. And
the remedies that you are seeking, are these not political questions? Can this court direct the government to allocate a budget or to specify a learning recovery program? How does a sustainable sort of students develop if we give such specific directions as have been sought by?
Can you please?
My question is this not within the political domain? The sort of remedies that you are seeking are extraordinary in the sense that you are asking us to allocate a budget, you are asking us to implement a very specific learning recovery program. Is that not a matter on which we should defer to the government?
It is admitted, Your Excellency, but even in previous cases, the Honorable Supreme Court has directed the executive and even the legislative to wherever they have failed to perform their obligations under the Constitution of Pakistan. The Honorable Supreme Court of Pakistan under Article 184 Clause 3, which can be read together with Article 199 of Constitution of Pakistan, which includes a certain risk. This Honorable Court can pass certain directions to public functioning bodies who fail to establish their fail to perform their obligatory duties.
But if you go to that direction, then the jurisprudence that we have presently is to allow for setting up a formation of commissions or other committees to then deliberate on the way forward. Would you be satisfied with such a remedy?
These remedies are just for the assistance of this Honorable Court. However, the intellectual people sitting before me, they know well how to address this situation and by what kind of remedies or direction the situation can be, and so that the children they can be their other constitutional rights like Article 9, right to life, right to human dignity, right to equality, and right to educate. They can be saved just by the providence of internet access.
Thank you, sir.
Thank you, Your Excellencies.
Now the responses will begin.
Counsel for the respondent, please state your name.
Umar Mukhtar. Good afternoon, Your Honor. May I please the court?
Please proceed.
Thank you, Your Honor. Your Honor, it is my sheer privilege to represent myself, Umar Mukhtar, on the behalf of the respondent. And I am a leading counsel on the behalf of the respondent, and I will be addressing issue number 1. And for that purpose, I will reserve 30 minutes, and my co-counsel Shahyar Pani will be addressing the rest of the issues, and for that purpose he will reserve 15 minutes, and we will reserve 2 minutes for the rebuttal. So Your Honor, now coming towards the first issue, that whether the UAF...
Counsel, take all the time in the world. This bench has specially assembled to hear this important matter. This is a concern for the whole nation. Take your time.
Sure, Your Honor. So, Your Honor, the first issue, whether the UAF has longer stand before the Supreme Court under Article 184, Clause 3 of the Constitution or not. So, Your Honor, basically, the UAF has no longer stand before the Honorable Supreme Court under Article 184, Clause 3 of the Constitution of Pakistan. And, Your Honor, I will prove this and establish this. But, Your Honor, first of all, it should be very important to know the term of a locus standi and what does it mean. It simply means the place to stand before the court, or it basically means the legal right of a person to file a case before the court. Your Honor, there are 3 requisites. So there are 2 requisites of Article 184, Clause 3 of the Constitution. As the petitioner side stated that there are let me correct them, there are basically 2 requisites of the Article 184, Clause 3 in order to invoke the jurisdiction of Article 184, Clause 3 before the Supreme Court. So, Your Honor, that requisites are the matter should be of public importance, And secondly, there should be violation of fundamental right of public at large, as it can be seen in the case of Anwar Aziz versus Federation of Pakistan, Mia Mohammed Shabazz Sharif versus Federation of Pakistan, and All Pakistan newspaper versus Federation of Pakistan. Basically, Your Honor, in these cases, it was held by the Supreme Court that in order to invoke the jurisdiction of Supreme Court under Article 184, Clause 3, there should be the minimum requisites, and that requisites are that the matter should be of public importance, and secondly, there should be violation of fundamental rights of public at large. And Your Honor, I will establish this one by one step that none of the requisites has been fulfilled by the petitioner UAF in the present case. So Your Honor, now coming towards the first requisite of the Article 184 Clause 3, which is question of public importance. Your Honor, the matter presented in this Moot problem was not of public importance because the petition was filed by the UAF on the behalf of 5 children. They are basically those, we can say, exceptional students which are due to their financial reason or private matter are unable to provide to access those means of education which are provided by the state, such as TV or radio. Basically, it's these 5 exceptional students are those who are unable to purchase those means of education just because of their financial condition or private matters. So that
Counsel,
is not a matter of
Counsel, are you suggesting that these are the only 5 students who are struggling to have access to education at this time? You're using the term exceptional. Are you implying that these are the only 5 students who are in this situation who don't have the financial resources to access it?
Your Honor, as the petition was filed on the behalf of these 5 children. So basically, they are very less in number, or we can say.
So, Counsel, would you suggest that they find every single student who is unable to access their education, and then they can file, then they will have the locus stand up?
Basically, Your Honor.
Here, let me reframe my question. Could there be other students who are in a similar position to these 5 students?
Yes, sir.
Yes. And do you suggest that perhaps the majority of the country, or are you saying that only very few proportion of this country lacks financial
I
resources?
want to say that very few portion of the country who are unable to basically the state provide the means of education, and the internet access is not the only means of education. The state provide other means such as like when the lockdown was imposed. Since the lockdown was imposed, he provided other means such as radio, television, telecommunication, and many various platform communications in order to protect the fundamental right to education of the students. And Your Honor, furthermore, it is not the duty of the state to provide those means, such means of education, such as TV, radio, specifically to each individual of the state. So that's why it is not a matter of public importance. So in this way, on this basis, the petitioner UF does not fulfill the first requisite of the Article 184 Clause 3 of the Constitution. Now you want to come towards second requisite, which is that there should be violation of fundamental right of public at large in order to invoke the jurisdiction of Supreme Court under Article 184 Clause 3. But Your Honor, if we see in our case, there was no violation of any fundamental right, because Your Honor, it will be established on my co-counsel that the right to internet access is not a fundamental right even in itself, because it is not declared anywhere, especially in any constitution of the Pakistan or in any law of the Pakistan. So basically, how it violates then the other constitutional fundamental rights. So that's why it not violate. There was no violation of fundamental rights of public at large. And furthermore, Your Honor, it is mentioned in the context of Article 184 Clause 3 that the violated fundamental right should be enshrined in the context of Article 184 Clause 3 in the Chapter 1 of Part 2 of the Constitution. So basically, the petition also lacking this part of the context, and does not fulfill the requisite of the Article 184 context of the Article 184 Clause 3 in mentioned in the Chapter 1 of Part 2 of the Constitution. So Your Honor, on this basis, the UAF has there is basically no violation of any fundamental right, and the UAF does not fulfill the second requisite of the Article 184 Clause 3 which should be fulfilled in order to invoke the jurisdiction of Supreme Court under Article 194 Clause 3.
Council, if schools are shut down and you are saying that right to internet access does not fall within that overall ambit, is this not a violation of Article 25A?
Basically, the schools are shut down due to there is an epidemic due to the break of epidemic. So it is basically the necessity of that necessity of the time to shut down the schools in order to save the other fundamental rights, such as right to life, for the public and security, for the safety and security of the public, in order to secure the fundamental right of the enshrined in the constitution of the public. So.
Suggesting that these are exceptional circumstances when we have
Yes,
to close
yes.
the schools and 25 is not violated. So why is not the responsibility of the state to provide exceptional things and exceptional facilities to the students so the right does not violate?
Much advisory, Your Honor. But as it is mentioned in the Article 38, Clause B of the Constitution, shall I read? Which states the state shall provide for all citizens within the available resources of country facilities for work and adequate livelihood with reasonable rest and leisure. Your Honor, it is clearly mentioned in the Article 38 Clause B that within the available resources of the country. And if we see in our case, in our present problem, the country was a developing country. It was not, they have not much infrastructural resources to provide other means such as right to internet access to each and every student.
Council, read the entire provision 38B.
It states the state shall provide for all citizens within the available resources of the country facilities for work and adequate livelihood within reasonable rest and leisure.
Yes, this is a proviso specific to work and livelihood.
Basically,
Is there any such proviso in the right to education?
like Article 25 basically.
Yes, does that say within available resources?
No.
Where does it say within available resources? Where the right is to livelihood and work.
You are asking about the provision in the
Yes,
Constitution.
the proviso that you are relying on within available resources. Yes, my understanding of your argument is you're saying that the Constitution says I only have to provide if I have the available resources. Is that what you're arguing?
Yes, Your Honor.
But that provision refers to work. Is there such a proviso in the right to education, or is that an absolute right?
Basically, I'm talking about the means of education, such as radio and other such as radio and television. It is not the basic duty of the state to provide that particular means to each and every student of the state. So, because it is impossible for a developing country like Pakistan.
Alright, Council, we have understood. Could you please finalize your submissions?
Now there is another point. So now there is another point which is forum and remedy. It is mentioned in the case of Mia Mubashir versus state that it has been laid down in this precedent in this case by the Supreme Court that whenever the party or person have another forum or remedy available to get or avail, then it will not be allowed to approach directly to the Supreme Court under Article 124 Clause 3 of the Constitution. So if you see in our case, the petitioner UAF directly approached to the Supreme Court under Article 184 Clause 3 without approaching to the High Court under Article 199. So that's why they also on this basis the UAF has no local standby before the Honorable Supreme Court under Article 184 Clause 3 of the Constitution of Pakistan.
Council will not agree, I'm on the right here, will not agree that as far as convenience is concerned, the appropriate forum, given that it extends to the entire territory of Pakistan, not just a particular province, would make it more appropriate for a Supreme Court with federal jurisdiction across the country rather than for a provincial high court to decide the issue. Would you not agree with that?
Your Honor, kindly can you summarize the question?
I'm asking whether you would not agree with the proposition that a subject such as this, which extends to the whole country, not just a particular province, it may in any case not be appropriate for a provincial high court to give the sort of remedies that are being sought. And perhaps a more convenient forum would be the Supreme Court. Would you not agree with that?
Basically, Your Honor, it is not a matter of there is no violation of fundamental right of public at large. So that's why the party has no local standard before the Honorable Supreme Court under Article 194, Clause 3. So that's why I want to say. So when they have got another remedy available, if they have another remedy available under Article 199 of the High Court, so before the High Court, so they should go to the lower level forum. They should not be allowed to approach directly to the Supreme Court.
But you suggest it's a pandemic. If it's a pandemic, then how is it not affecting public at large? I'm just not understanding that.
And also, you just have some assistance from one of your team members. Could you please look at that and state what is the reply concern raised by
Much obliged.
Honorable Member Judge? Yes, please.
Your Honor, basically both the court, the Supreme Court and the High Court have jurisdiction. But the question is that the question here is issue was of the provincial subject. So that's why they have to go to the Supreme Court to the article under Article 199 before going to the directly approach to the Supreme Court under Article 194 Clause 3 of the Constitution.
Thank you very much, Counsel. We appreciate your assistance.
Now I would like to invite my co-counsel, Sharia Al-Mani, to proceed further.
May I please the court?
May we know your name, please?
My name is Sharia Al-Mani, Your Honor.
And what do you have to say today?
Your Honor, first I humbly refer the Honorable Court to paragraph number 22, which specifically states the last lockdown was lifted many months ago, and since September 2021, schools and other educational institutions have been physically open for learners and teachers. This is very important in context to the issues that I will speak on. I want to get the most glaring and obvious contention out of the way. Right to internet access has not been recognized as a fundamental right under the Constitution of Pakistan. It has not been expressly declared. And this is very important to note because when there are cases of other states referred, for example, the Indian Constitution's case of Fahim Bashir versus State of Kerala, the Indian Constitution has expressly recognized internet access as a fundamental right. However, the state of Pakistan has not. So this is an important point to note. And this is a dichotomy that exists between our and their judicial system. I would also like to refer to the case of Sayyid Mahmood Akhtar Naqvi.
Sorry, Councillor, could you just push the mic down a little bit?
I'm sorry. Is it okay now?
Yeah, could you please maintain some distance between guests so that there's some clarity in your speech? Yes, please.
I apologize. In regards to the case of Sayyid Mahmood Akhtar Naqvi versus Federation of Pakistan, it was stated that a literal rule of interpretation should be used when applying the law, and in light of that, the correlation between internet access constituting a fundamental right cannot be joined. Although this council recognizes the purposive approach, but we need to recognize that the recognition of internet access as a fundamental right is a very conflicted topic. I would also like to point out that the alleged grievances of the petitioner have been built around the unforeseen circumstances of the COVID-19 virus. And in this specific situation, it was on that basis that the petition is brought before this specific court. So if the situation has subsided and the lockdowns have been lifted, the alleged grievances have not been addressed as to the remedies, including the remedies is why they're seeking it now. I would also like to address that the recognition of internet access as a fundamental right across the world, specifically the UN Declaration of July 2016, did declare it as a human right, but it is at the discretion of the state, because internet access is one of those technologies which is not uniform in all states. For example, USA or Ghana, these are both states which have a different level of access to it. Another important point I would like to raise is that fundamental rights are not absolute. We have seen in Article 9, for example, if the Honorable Court may refer to Article 9 of Constitution.
We know what it is.
Of course.
Proceed.
The security of person. No person shall be deprived of the life or liberty except in accordance with the law. And this is very important to note because the issue that is presented here, we have to recognize that this was an extremely exceptional circumstance brought before the court. We have to recognize that the right to life was not violated because the most important fundamental aspect of right to life is the preservation of it. And as the respected opposing counsel did present the case of Ahmed Abdullah versus Government of Pakistan, where they said, talked about the right of education. And I refer to Shehrazad versus Baghdad. An excerpt from that case specifically states that right to life also includes the enjoyment of life. But as I've also established, the enjoyment of life can only be done when it has been preserved. And in this specific situation, if it is not preserved, how can the other fundamental rights be applicable? I also refer to the Epidemic Diseases Act of the Sansedabad Infectious Diseases Act of 2020, which laid out that specifically that lockdown can be ensued. It is a given that in an emergency situation such as this, the need of the hour is to impose such laws as will meet for the protection of the people itself. We know that if a lockdown is imposed, it will directly be in conflict with your right to assembly. So it is a given that the right to education and your other fundamental rights will be affected if the preservation of life is to be maintained. I would also like to refer to the Honorable Court to paragraph number 19, which specifically states that the government did take measures such as the inauguration of a dedicated teleschool and a radio school for students to access learning material from home. We also have to see that Federal Ministry of Education in Pakistan has introduced vast range of edtech platforms to provide students and teachers with educational content while lockdown ensues. So this shows that the government did make all the efforts that it could with the means and resources it had at hand. It is important to remember that a lot of the resources had to be invested with the preservation of life and to the maintenance of public health itself. So the demand that they also provide children with the right to education, it is very far-sighted in this council's opinion.
Counsel,
Yes.
the applicant suggests a number of different remedies. What you're suggesting is that we are unable to provide internet access to every single individual. But they've also suggested something called a learning recovery program in the memorial. And what you say is that the pandemic has subsided, lockdown has ended, so there is no reason for this petition. But one of their points is there could be a 12-week learning program or something of the sort. How do you address this remedy?
I am obliged, Your Honor. I have to state that it is a given that after schools will reopen, that the schools will take measures to properly inculcate students into the effective learning programs. After all, it is a given. So I do believe that after schools have opened after 18 months, the schools will already have taken the measures. And it is September 2021, after 4 months. So you cannot expect recovery learning programs after 4 months.
So would you be willing to accept that this is a remedy this court should grant?
Your Honor, but my point of contention was that it has already been 4 months and the re-inauguration of the students into the learning program, and the time has passed for that remedy. I would also like to redirect the court to paragraph number 20, which states, as stated by the Federal Ministry of Planning, Special Initiatives and Development, that the adequacy of the emergency measures taken in the education sector to combat the pandemic, and that it is impossible for a developing country like Pakistan to provide internet. And as stated in paragraph 21, second line, these departments have also outlined the provision of access to the internet would also mean putting in place the enabling infrastructure, broadband connections, provisions of IT, etc. So the point remains that if there wasn't an established infrastructure before the COVID-19 virus, how can they expect that after the lockdown ensues that there will magically appear a structure for internet access to the children? In exceptional circumstances, it is given, and the practicality of it also recognizes that the government is unable to do it. I would also like to refer the court to
Refer the Honorable.
Honorable Court. Of course, I apologize.
Slip of tongue, master.
Yes. Also, I have to point out to the Honorable Court that if we are stating that lack of internet access has violated fundamental rights, this given case, we have seen, for example, with the case of Shumailia, that she already did have access to the internet. So how can the lack of it violate any of her fundamental rights? and we can recognize that even if internet access was provided, in these exceptional circumstances, the right to education of children still would have been affected. That is a given. Another important thing to note is that, for example, with Zulfi, we saw that he had to work. He had to work in a brick kiln, and he had to child labor laws were not enforced. But the point of the matter still remains that lack of internet access would not have fixed the issue.
Council, you have cited these federal ministries in paragraph 20, and your colleague has also mentioned that this is a provincial subject. Can we take the perspective of these federal ministries on board pertaining to education when you yourself state that it is a provincial subject? Are they competent to tell us that what measures should be taken and shouldn't be taken?
Could you rephrase your question?
The ministries you have referred to in paragraph 20 are federal ministries. You have said that education is a provincial subject. These federal ministries are weighing in on a provincial subject, i.e. education. Can they do that?
Your Honourable Court, they cannot, but the point still remains that they are weighing in on the practicalities of the application. And as I have also highlighted, that the infrastructure cannot be set up. So the petitioners have not justified how the government or the provincial government wants to automatically set up that infrastructure and provide children while also redirecting the necessary needs to the public in the matter of public health.
So they are providing a technical opinion that it cannot be done in the requisite time.
Yes.
Thank you.
Yes. If the Honourable Bench has any other questions, I could address.
You could just conclude your.
Yes, so the final point.
Before you do conclude, in your memorial you've drawn extensively from amongst other sources the provision of Article 233 of the Constitution. Is Article 233 of the Constitution invocable without there being a proclamation of emergency?
Your Honour, that is a mistake on our part, unfortunately. Article 232, which specifically refers to emergency provisions, which is under the presidential order, and this was not applicable. But I will highlight the point which I wanted to make earlier, and this was to show that fundamental rights are not absolute. So, under Article 233, fundamental rights can be suspended, and it was in that context. Is there any other questions from the Honourable Bench?
Thank you.
Thank you. Thank you, Honourable Bench.
Now the applicants may come for the rebuttal.
Yes, could you be very precise in your rebuttals?
Sure, Your Excellencies, I will try my best. First of all, I am very disheartened to hear the arguments of respondent that a state who is not only violating the fundamental rights but also a social contract theory which they have with their own citizens by escaping their obligations under the Constitution of Smogistan. Firstly, my learned counsel said that the petition has become infructuous because the pandemic situation is no longer available. However, according to the directions of NCOC, that is the organ of Smogistan, it said that on 21st January that the situation is still surging and the whole Smogistan is going to be under lockdown again. So the matter has not become infructuous. Secondly, education is a provincial subject that has been argued by my learned counsel. It is admitted that education is a provincial subject. However, the reliance is placed on opinion of Wazia Rafiq and another scholarly opinion that has been cited. If my researcher can just hand me over. And a research paper is published by the Pakistan Institute of Legislative Development and Transparency. These both documents justifies that the enforcement of the 25A of Constitution of Smogistan, the federal government cannot escape its obligation under said article.
Council, could you confirm if this is also cited in your memorial?
It has not been cited in the memorial, however, we are just arguing for the sake of answers and rebuttals.
Thank you.
Furthermore, my learned counsel argued that other remedies should have been invoked. However, if you just read Article 184 Clause 3 of Constitution of Smogistan, it doesn't require the exhaustion of alternate remedies or other remedies. Further reliance is placed on, if I have extension of time to assist
Yes,
on
please proceed.
Further reliance is placed on the case of Sherwani versus Government of Smogistan, wherein the Honorable Court held that this Honorable Court is competent to entertain a constitution petition if it considers that a question of public importance with respect to enforcement of fundamental rights is involved, notwithstanding that there might be an alternate remedy. Therefore, without considering the fact of alternate remedy, jurisdiction under Article 184(3) can be invoked. Furthermore, my learned counsel argued that Europe has not established, they have not established, they have just tried to mislead the Honorable Court by citing that these were exceptional circumstances or unforeseen circumstances. However, it is the obligation of the state to allocate a specific budget to address these kind of emergency provisions despite of just violating their fundamental rights. Furthermore, my learned counsel also argued that it is up to the availability of resources. However, for the sake of rebuttal, we rely on the case of Octavia P. versus Gilhold, wherein the Honorable Court held that in the light of Article 25A, the Court held that the state could not escape its constitutional obligations on the pretext of budgetary constraints. As the right to education was justiciable under the Article 25A of the Constitution of Smogistan, and school could not be closed without providing alternate educational facilities, that is the right to internet access. They might have provided internet access in these exceptional circumstances. Furthermore, my learned counsel...
Furthermore, please. Could you please give your last point and your time is over.
Pardon me, I much obliged. My learned counsel also argued that there was providence of education through radio and TV, but not every student had access to radio or TV. And even those who had, they were discriminated, like in the case of Shaheen and Shumalia. And with this, I rest my case before the Honorable Judge.
Thank you.
Now the respondents may come to Sarabur.
Honorable Bench, I would like to point out that one of the remedies that the applicant seeks is that the school must be reopened by following the SOPs, but as I have to clearly point out that they already have been opened. Another important thing to note is that they have failed to recognize the value of right to life, and they kept reinforcing the importance of right to education. But as previously highlighted, that right to education can only be maintained along with all the other 18 provisions of the fundamental rights if the preservation of life is done by the state. And their requirement of devices being provided to the children along with all of the internet access, it seems not only impractical, but if a person is unable to get access to the internet, how is it that the state will also provide mobile devices or laptops? If for example, the state of Smogistan has a population of 230 million, even if we state that 50% of people have access to the internet, how can the petitioner expect that over 100 million people, for example, will be granted access to the internet and provided devices? So on that fact, this remedy does seem frivolous. I would also like to point out that again that all fundamental rights are not absolute and they are subject to the law and as mandated by Article 9. That is all. Thank you.
Thank you.
May the management please escort the judges.